like we just had our lunch. Hello Makati, hello world. This is Attorney Angel and I'm your legal angel. Hi my fellow angels. I hope you are all doing well. Another week of learning, and this time I'm sharing with you my supplemental lecture on the rules of construction for specific statutes. Enjoy listening. Hello and good day to everyone. This is Attorney Angel Valero Nunez for statutory construction. This is a supplemental lecture for the topic on rules of construction for specific statutes. And I will divide this discussion into two parts. Part 1 will include rules of construction for penal statutes, tax statutes, and social legislation statutes, while Part 2 will cover the rules of court, adoption laws, local government, local autonomy, and constitutional construction. So let's start. First up are penal statutes or penal laws, but let us first define what penal statutes or penal laws are. They impose punishment for an offense, command or prohibit certain acts, and establish penalties for violations. Recall that in our Latin maxims discussion, one of the Latin maxims is that nullum crimen nulla pena sine lege, or this directly translates to there is no crime when there is no law punishing it. And the specific rule of construction for penal statutes is that penal statutes are to be liberally construed in favor of the accused. In the case of Centeno versus Villalon Pornilios, the Supreme Court held that penal laws are not to be extended or enlarged by implications, intendments, analogies, or equitable considerations. They are not to be strained by construction to spell out a new offense, enlarge the field of crime, or multiple felonies. And in the case of U.S. versus Go Chico, the Supreme Court said that the intention of the lawmakers must govern in the construction of penal statutes. That, though penal statutes are to be construed strictly, they are not to be construed so strictly as to defeat the obvious purpose of the legislature. Now, moving on to the next, the tax statutes or tax laws. Tax statutes or tax laws impose rules and regulations related to taxation or to creation of particular sources of revenue such as, of course, taxes, fees, and charges that are needed for the support of government and for public needs. Now, the rule of construction for tax statutes is that tax statutes are construed strictly against the taxing power and liberally in favor of the taxpayer. A tax statute will not be construed as imposing a tax unless it does so clearly, expressly, and unambiguously. And there are also additional rules on the interpretation or construction of tax statutes. One of which is that the real purpose of the legislature, if that purpose is discernible from its statute, will prevail over the literal import of the words used. Another one is that the spirit rather than the letter of an ordinance determines the construction thereof, and the court looks less to its words and more to the context, subject matter, consequence, and effect. Now, also, the history of the statute should be considered as an aid in the ascertainment of the intention of the legislature. And however, tax exemptions are construed strictly against the taxpayer and in favor of the taxing power. Okay? Moreover, tax exemptions cannot be claimed unless they are expressly provided for in the law or by law. Now, take note of the case of PRA versus the City of Parañaque, wherein the Supreme Court held the tax exemption in favor of a national government instrumentality. All right. Now, the last, under Part 1 of the Rules of Construction for Specific Statutes, social legislation, or labor laws and social legislations. And these deal with employer-employee relations and labor standards, as well as compensation, benefits, grievance procedures, and of course, social justice, and the promotion of the welfare of the people. Now, in your constitutional law subject, I am sure that you discussed about Calalang versus Williams. Let us recall that in that case, Justice Laurel made a historical classic statement on social justice. Justice Laurel said that social justice is neither communism, nor despotism, nor atomism, nor anarchy, but the humanization of social and economic forces by the state, so that justice in its rational and objectively secular conception may at least be approximated. Very nice, beautiful quotation from Justice Laurel as stated in the case of Calalang versus Williams. Now, in our discussion of several cases, time and again we have mentioned about PD 442, otherwise known as the Labor Code of the Philippines. And in the Labor Code of the Philippines, the construction itself is provided for. Particularly in Article 4, it states that all doubts in the implementation and interpretation of the provisions of the Labor Code, including its implementing rules and regulations, shall be resolved in favor of labor. Also, in the Workmen's Compensation Act, it is stated that liberal construction is given in order to fully carry into effect its beneficent provisions. Okay? This law should be construed fairly, reasonably, liberally, and all such doubts as to the right of compensation should be resolved in favor of labor, and all presumptions indulged being in their favor. Okay, so you may check out the case of Bautista versus Murillo, wherein the Supreme Court ruled that the casual employee engaged in the business of the employer is entitled under the Workmen's Compensation Act. Thank you for listening. Please like, subscribe, share, and follow. Be kind, be a blessing to others, and always remember to glorify God with a grateful heart. This is Attorney Angel, and I'm your legal angel. Stay safe, everyone.